Welcome to everybody on this unseasonably warm late October afternoon in central New York. We're glad that you are with us this Tuesday. We have a great program for you, and I don't want to delay anything, so let's get right into it. First up, I'm going to do my normal COVID update. You can see that case numbers have remained fairly consistent across New York over the past 90 days. We've seen a significant increase in cases there. If you look for the 14-day change is plus 22%, most of that is coming from the New York City and surrounding areas, but that's something certainly to keep an eye on. Next slide, please. In terms of the color map, this is pretty good. We like to see lighter orange, if not yellow. Again, the only concerning thing we're looking at is what's going on in New York City. 14-day change of plus 8%. Rather than looking at the actual number of daily cases, which is the far left column, it's better to look at the per 1,000 case numbers, because that gives you a more uniform look at how we are doing. New York City is obviously not doing great. Wyoming County, we see these huge spikes in smaller counties, but you're looking at only 10 new cases in Wyoming County over the past, at the daily average for the last 14 days. So something to keep an eye on, increasing cases. We will certainly monitor any policy changes. For right now, we haven't seen any, and we're not hearing about any, including changes to New York's COVID paid leave law. I know that's something that is on many of your minds, what's going on with COVID paid leave. I will be doing an update on that in the coming weeks. All right, so that's it for my portion of the webinar. Let's get into the interesting topics. The first presenter is Frank Mayer. Frank is a member in our Albany office who specializes in tax issues. And one of the unique issues that has arisen from the pandemic and the aftermath of the pandemic is what to do with taxing employees who are working remotely, telecommuting from other states. So Frank is here to talk to us a little bit about that. Frank, welcome.
Oh, thank you, Adam. It's nice to be here. It's been a while since I've had an opportunity to speak with this group, and I want to talk today about a little known public secret is about workers performing services remotely. The last time we discussed this topic, we were dealing with workers performing services in the United States. Let's say someone worked for a New York employer, might be working in Pennsylvania for that employer. And based on some of the feedback from that last seminar, I've kind of narrowed this down to workers performing services for employers from abroad. Now, that is a much more narrow issue, but nonetheless, it's becoming increasingly important, is that sometimes the employer is the last one to know, we like to say. So many times a US company, a New York company, for example, or Delaware company may send a US citizen or a US resident to work abroad. And, you know, there are a variety of issues that one would have to deal with there. For example, immigration issues in the host country, as well as the labor law issues in the host country, which would typically apply to workers performing services in that jurisdiction. And the third part of that, which we're going to talk about today, is taxation. So we're going to talk about two groups of workers: one, US citizens and resident aliens working abroad, and then non-resident aliens working abroad. And I hate use the term alien, but that's what the statute says for now. So US citizens and resident aliens are taxed essentially the same way, that is, on their worldwide income. They're basically going to be, if let's say we send someone to work in the UK or in Germany, generally that person is going to be subject to taxation, withholding, and reporting in the host country. And depending on whether or not that country has a treaty with the United States, which we'll talk about in a minute, the urgency in dealing with the tax issues is increased if there is no treaty. Workers, U.S. citizens, and resident aliens who do work abroad may be eligible for a U.S. earned income exclusion and a housing allowance if their so-called tax home, not where they live, but where they're assigned to work, is deemed to be located in a foreign country. So just as a basic principle, a person's tax home isn't where they live. It's where they're assigned to work, regardless of where they may live. So, as I said, U.S. citizens and resident aliens are taxable on the worldwide income. So if they earn $1 in New York, it's taxable in the U.S. in New York. If they earn $1 in London, it's taxable by the U.S. on a worldwide basis as well. And then any taxes that person might pay in the U.K. is perhaps creditable against their United States income tax liability. The foreign tax credit is the mechanism used to mitigate double taxation, but it's not perfect, as many practitioners will tell you. So with regard to what an employer needs to do, I mentioned that there are certain tax treaties. The United States has tax treaties with approximately 70 countries in place. They're organized by articles, and they're subject to amendments, or what we like to call protocols. If there's a tax treaty in place, if a worker is sent to work abroad, they may not be subject to income tax in that jurisdiction if they're there for less than 183 days. Every treaty country has a different treaty provision, but 183 days is typically the rule. Now that's for income tax. That doesn't typically affect Social Security taxes, which is covered by a different type of treaty called a totalization agreement, which there are far fewer of, and which we'll get to in a second. So if an employer sends someone to work in the UK, likely there's going to be some registration requirements on the US employer to register to, at some point at least, register to withhold income tax and provide lawfully required employee benefits, as well as the immigration issues, which are beyond the scope of this presentation. Without a treaty, in a country without a treaty, the obligation to withhold tax and pay tax accrues from day one. So the treaties are a helpful thing. They'll never make a taxpayer worse off. They're designed to help make a taxpayer better off. The United States has totalization agreements, which are basically a fancy term for Social Security treaties with about 30 countries to prevent the double taxation of Social Security. Without that, employees could be, US employees sent abroad could be subject to Social Security taxes in the United States, as well as Social Security taxes in the host country. I mean, think about that. Would that be like to double up on Social Security? So these agreements for the 30 countries that we have agreements in place for help. Employers get basically what's called a US employer would get a certificate of coverage for the employee they send to work, let's say in the UK, and under something we call the detached worker rule, if the person is sent to the UK, for example, to work for 5 years or less, they would only pay US Social Security taxes and not UK Social Security taxes, even though they may end up paying UK income taxes if they blow through the 183 days that happen to be in that particular treaty. So, you know, to kind of summarize that part of it. So if you send someone to work abroad, they're taxable, US citizen, resident alien, they're taxable on their worldwide income, and the employer has registration and reporting obligations in the host country. Typically, our clients we help our clients connect with local counsel that can help with these registrations, that being local law firms and sometimes accounting firms that can make sure the right documents get in place and that the employee is furnished with a copy of let's say the UK version of a W-2, for example, because all of this would be, uncharted territory for most employers to know what the requirements are in another country It's sometimes challenging enough to know what we're supposed to do in the US. So to deal with some of these issues, US employers look for different ways to structure their relationship with workers, of course, subject to the labor laws in the host country. The first would be the direct employment, which we've been talking about. Another way to deal with such an issue is an employment by a foreign affiliate. You know, in an ideal situation, a US employer would have a foreign affiliate that could employ the worker. And if that's the case, the foreign affiliate would have, let's say, the infrastructure in place to employ the worker, and then could just charge back the cost of the worker to the US company. They're set up for withholding and reporting. So it would just be old news to the foreign affiliate to add one more worker. Another opportunity is to use what's called an employer of record. It's kind of like a PEO, a professional employer organization, that would employ the US worker in the foreign jurisdiction, and they would provide an employment contract with the worker to be reviewed by local counsel and kind of overseen by us, and they would be the employer of record. And then the US employer enters into an agreement with the PEO for services and chargebacks back the costs. That can cost about 10 to 13%, I would guess, to have that in place. So that's not, without costs of doing that. And then the other alternative is to use classify the worker as an independent contractor. And just so if my labor colleagues don't jump out of their seat, I say that with Adam smiling. I say that with a grain of salt, that worker relationship really needs to be looked at carefully by local counsel, as worker classification issues differ by country, but they're often quite similar, dealing with the issues of behavior control, financial control, and relationship type. And if they could pass that muster in the local jurisdiction, then some of these issues would go away. Beyond just the worker, the employer sometimes has to deal with issues, or often has to deal with the issues of avoiding what's called creating a permanent establishment in the foreign country. Under the treaties that are in place, the 70 treaties, the concept of a permanent establishment is well defined: an office or fixed place of business, or a permanent establishment can be created when a worker has the ability to conclude contracts in the name of the company. I would say the company or the employee. So that could create a permanent establishment. And creating a permanent establishment puts the burden on the employer that they may need to register to do business in that jurisdiction, and may have to file a corporate income tax return in that jurisdiction, or a not-for-profit tax return in that jurisdiction. But they would also have to get not-for-profit status in that jurisdiction to avoid tax, because not-for-profit status granted in the US isn't necessarily recognized in a foreign jurisdiction. So there's that. So again, issues for the employer from an employee withholding and reporting point of view, employee benefits point of view, and beyond that, issues for the employer in registering itself to do business if the transaction isn't structured correctly. And again, we talked also about the immigration issues, which would have to be handled on the other side of the pond. The other side of this type of thing is dealing with hiring someone abroad, what would be a non-resident alien, someone who doesn't have a connection with the United States. Now, that's a little bit easier pill to swallow for a US employer, because if you have a non-resident alien performing services abroad, they're only taxable on their so-called US source income, and wages are considered sourced where the services are performed. So going back to our UK example, if you have a UK worker performing services in the UK for a US employer, there's no US withholding or reporting obligation for that UK worker, because there's no US source income for that non-resident alien individual. But there would be sort of what we mentioned before, the obligation to register and provide income tax withholding, social security or social insurance, as the country may refer to it, and lawfully required employee benefits in the local jurisdiction, as well as dealing with the rules for termination of an employee, which might be a lot more broad-based than what we would expect here in the US. And that's why it's essential that whether we're working with a citizen, resident alien, or a non-resident alien, that local counsel review any kind of employment contract that we have with the worker. Again, as we mentioned, with the US citizen and resident alien workers, we need to avoid the permanent establishment issues under the applicable treaty if one exists for the same reasons. So we don't end up filing corporate tax returns in another jurisdiction, which is time consuming and pushing a lot of paper, even if it's not going to create an incremental tax liability. Structuring a relationship with the non-resident alien worker could often be done the way it's done with the US citizen or resident alien worker by the direct employment, which we've just talked about, employment, or I should say, employment with a foreign affiliate, use of the PEO that we've spoken about earlier, and if reasonable and possible, using an independent contractor. And again, all of these things would be vetted by foreign counsel so that we make sure that we're in the right compliance seat regard to whether it's an employee or an independent contractor or something in between with the PEO that we're using. So again, you know, to kind of put a cap on this, while it's great that employers can expand their recruiting base by using workers worldwide, you know, there are a lot of issues to deal with, compliance issues to deal with in various jurisdictions. So what might work in the UK might not work in Germany, but might work in Hong Kong. So it's important to really examine each jurisdiction and get local counsel involved in each of the jurisdictions to make sure that the US employer is compliant with whatever type of worker or location of worker they're using abroad. So if anyone has any questions, I'd be happy to take them now. I hope everyone is still awake. I tried to make this as brief as I could because I know tax can be painful for people that don't love it as I do.
Well, Frank, thank you. It was not boring or painful. We appreciate the insight on very complicated tax issues. And as I typically say when our employee benefits colleagues are on, I don't know anything about that area of law, so please reach out to Frank if you have any questions. All right, next up, we have Kristen Smith. Kristen, it's great to have you on the webinar. Kristen is a member in the Labor and Employment Department here in Syracuse. Kristen was the corporation counsel for the city of Syracuse for the past 4 years, and she has kindly rejoined us in the Labor and Employment Department. So Kristen, welcome. And she's here to talk to us about some recent discrimination litigation.
Thanks, Adam. I was actually going to start out by saying that my earlier experience with this webinar is as a client, or was as a client. I remember watching this when I was corporation counsel. So great to be presenting now. As Adam said, I'm going to be talking about a recent decision in discrimination litigation. If you can just advance the slide. I do have a few slides because I know I'm a visual learner, so I thought some of you might appreciate that as well. I want to talk about a decision that just came out this month, but in order to explain it, I need to go back and give a little history. So 2 years ago, there was a major US Supreme Court case that I'm sure that we talked about earlier in various webinars, but it was the Bostock decision in June of 2020, in which the US Supreme Court said, we are now going to interpret Title VII to prohibit not just gender discrimination, but also sexual orientation discrimination and gender identity discrimination. Before 2020, many courts had said that Title VII did not cover such categories. And so under federal law, sexual orientation discrimination and transgender discrimination were not a thing, although they have been under state law, which I'll talk about in a minute. But so this was a very, very big decision back in 2020. So fast forward 1 year, and if you could fast forward the slide as well, there was the EEOC came out with guidance, as it often does, and it will often publish this guidance on its website to interpret the law, give practical information to employers. So in June of 2021, the EEOC issued this guidance about the decision and gave examples, as it always does. And it said, okay, these are some ways that an employer might engage in sexual orientation or gender identity discrimination. And 3 of the examples are significant here. For the first, it deals with dress codes. And what the EEOC said was that it would be unlawful to prohibit a transgender employee from dressing consistent with their gender identity. They also talked about restrooms and said it would be unlawful to deny access to a restroom corresponding with the transgender employee's gender identity. And then they talked about pronoun usage and said that repeated intentional use of the wrong pronoun could be a form of a hostile work environment. So these aren't surprising examples to many of you. If you're in New York State, these things, we would be advising you that these things would be unlawful under New York State law, because again, under New York State law, sexual orientation and gender identity discrimination have long been covered by the New York State human rights law. If you could move forward another slide, then more recently here in 2022, the Department of Health and Human Services, out of its Office of Civil Rights, also issued some guidance. And what they said was that denial or restricting gender affirming healthcare would be a form of sex discrimination, again, relying on that US Supreme Court case. What's interesting about this case is it was very explicit that it was being issued in response to an action out of Texas, where the Texas governor directed its State Department of Family and Protective Services to start looking into gender affirming surgeries in minors. And the guidance was directly in opposition to this, to make clear the federal government's position that under the laws that HHS enforces, gender identity is protected as a form of sexual discrimination. It's a protected category. So if you could move forward again, this brings us to why we think this is relevant here in October of 2022. Just this month, on October 1st, a decision came out of the Northern District of Texas, the federal court down there. What happened was, after the EEOC issued its guidance, Texas filed a lawsuit saying the EEOC exceeded its authority and misinterpreted and overinterpreted the Bostock decision. And then when the HHS issued its guidance in March, they amended their lawsuit. And what happened just this past October is this federal court judge in Texas agreed with the state of Texas and said, yes, this guidance is not lawful. It's not consistent with the Supreme Court decision in 2020, and it completely vacated this guidance. So if you go to the EEOC website right now and you look for its June 15th, 2021 guidance, there will be a note on it that this has been vacated due to a federal court decision. Same with the HHS guidance. So very significant, well, somewhat significant, and I'll explain sort of what the practical implications here. But it's not frequent that a federal court will vacate EEOC guidance. We don't see that very much. So if you could just go forward another slide so I can kind of explain what was going on here. The legal issue in this decision was somewhat of a subtle one, because you wonder, well, how could they say that the EEOC exceeded its authority and was incorrect? And you just told us that there was this Supreme Court decision. The key issue in the state of Texas case was the Bostock ruling limited to discrimination based on the status, being a gay person, being a transgender person, just the fact that you are and you can't be fired for it, or the conduct that is related to that status? And of course, the EEOC said it's the same thing, but they said it's inextricably intertwined. You can't separate one from the other. If it's unlawful to fire someone because of their gender identity, it's also unlawful to treat them differently in other ways in terms of the conduct that might be associated with it. So, for example, in the HHS guidance, to deny them surgery, or in the context of the EEOC guidance, to you intentionally use the wrong pronoun. The court disagreed, though. The court said, no, if you read the Bostock decision, it was actually very, very narrow, and the language used repeatedly by Justice Gorsuch was that the fact of being, lesbian, gay individual, or being transgender is what's protected. And the fact patterns in that decision in 2020 were about just being fired for that status. What the court in Texas said is, you took the decision too far. You were taking you were making your own interpretation that no court has entered into yet. And there actually was decision in this Supreme Court decision in 2020. There was language in the decision that really did try to limit the holding. So, it's a little bit of an academic discussion here, right? But it's an interesting case, the way that this federal court judge really sort of split this hair, you might say. And what the court said was, future cases really have to decide this. You, EEOC and HHS, you can't do that. You went too far. So if you can go forward one more slide, let's talk about the practical implications here. So the EEOC guidance is no longer good law, I would say, or it's not reliable guidance. But let's really be real here. Most of us here are in New York State. New York State already prohibits discrimination on these bases. So we've already been giving you advice that you shouldn't, that it would be unlawful to do those things that the EEOC pointed out in their guidance. That you do want to afford employees the right to use the restroom of that they associate with. That it's tricky to to discipline someone or hold someone to a dress code that doesn't correspond to their gender identity, and all those things. We've already been telling you this under New York State law. If you are not in New York State, or if you have employees outside of New York State, I think it's still significant, because clearly this is the interpretation that the EEOC, they've come right out and said it. This is how the EEOC views it. And even though this guidance is no longer in effect, when the EEOC pursues future litigation, this is the position that they're likely going to take. So it's not like this is open season and there's no longer protections for employees at a federal level. And really, when it just boils down to it, regardless of your state, it's best practice to treat individuals with equality in the workplace. So very interesting from a legal perspective, sort of an interesting case to read. And it catches your attention in the news when you hear that a federal court has struck down EEOC guidance. But from a practical perspective, not too much has changed. So that's all I have. If you have any questions, I'm here.
Kristen, thank you so much. It's very interesting to see the clash between the EEOC and other governmental agencies and the courts at times. And this is an example of where the courts are trying to rein in a federal agency and its interpretation of the Supreme Court decision in Bostock. So thank you, Kristen. Appreciate it. All right, next up, we have Mallory Campbell. Mallory's been on this webinar. If you've been attending religiously for the last 2.5 years, you had seen Mallory quite a few times early on. Mallory's here to talk to us about a new proposed rule relating independent contractor status. This is relating back to something Frank talked about. There's a new proposed rule that may change how employees can be classified. So Mallory, welcome.
Thanks, Adam. It's good to be here. As Adam mentioned, I presented a lot back in 2020, but it's been a while since I've been on. So good to be back, and thanks everyone for joining. So I'll be talking a little bit about this new independent contractor rule. On October 11, 2022, the U.S. Department of Labor released a notice of proposed rulemaking that would revise the analysis for determining independent contractor status under the Fair Labor Standards Act. It is important to properly classify employees and independent contractors, since employees are entitled to certain protections and benefits that independent contractors are not. So, for example, under the Fair Labor Standards Act, only employees are entitled to minimum wage and overtime pay. Misclassification of employees as independent contractors. So if you have individuals that are classified as independent contractors when they should really be classified as employees, can have pretty serious consequences for employers. We've seen a lot of litigation lately relating to this issue, and you may have seen headlines with Lyft and Uber. Lyft settled a class action lawsuit for $27 million on this worker misclassification issue. And if we could just go to the next slide, please, Kathy. Thank you. So the standard for independent contractors under the Fair Labor Standards Act has been pretty consistent from 1940 to 2021. It's this economic realities test that you see on here. Basically, what the courts do is they analyze whether an employee is economically dependent on the employer for work or if they're in business for themselves. So they look at these 6 factors: degree of an employer's control, workers' opportunity for profit or loss, workers' investment in equipment or materials, whether the work performed requires special skills, the permanency of the working relationship, and whether the services rendered were integral to the employer's business. So using this test, there wasn't any factor that was more or less important than the others. The courts would look at all of these factors, look at the totality of the circumstances. This all changed last year. So in 2021, this test was completely changed. It was pretty much set for 80 years, but in 2021, we did see this change. Under Trump, the Department of Labor issued a final rule on January 19, 2021, which was Trump's last day in office, with the rule becoming effective in March 2021. It basically said that the first 2 factors, the degree of control and opportunity for profit and loss, are the core factors. So more consideration should be given to those first 2 factors than the others. It also removed the 3rd factor, the factor about the worker's investment, and it limited consideration for the 6th factor. And instead, it asked people to consider whether a worker's services were an integrated unit of production. The 2021 test made it much easier to classify an individual as an independent contractor. When President Biden took office, his administration attempted to stop that 2021 rule, but was without success. Another Texas court decision, this time Eastern District of Texas, issued a decision that Trump's rule did become effective in March 2021. So this new proposed rule would totally rescind that 2021 rule and return to the original economics reality test. So to eliminate the heightened value placed on those first 2 factors, what they called the core factors, and return to the totality of the circumstances analysis. It reinstated that 3rd factor, the investment factor, and it returned to asking whether the work performed is critical or central to the employer's business. The proposed rule also provides additional analysis for the control factor, discussing how scheduling, supervision, price setting, and the ability to work for others are to be considered. If this rule is finalized, it would reduce the number of workers who can be treated as independent contractors. And as I mentioned, this is just a proposed rule. It's still in the proposal stage. The Department of Labor has invited public comments until November 28th. So we'll be keeping an eye on this and we'll let you know if we have any changes.
Mallory, thank you so much. So this is a very important issue for those of you who classify workers as independent contractors. Under the Trump administration rule, it was much easier to classify individuals as independent contractors. And now if you've done that, and this new rule comes into effect, there may be some enforcement agencies reaching out to you, and challenging how you are classifying workers. I know that's the last thing many of you want, to get that tap on the shoulder from the New York State Department of Labor or from the Federal Department of Labor. So we will keep an eye on that and keep you updated. Thank you, Mallory. Okay, next up, we have Maureen Milmo, who is an attorney in our business department here in Syracuse. And she is going to give us some information about some recent New York SHIELD Act enforcement. Maureen, welcome to the webinar.
Thank you, Adam. I'm happy to join you today to talk about the New York State SHIELD Act. October is Cybersecurity Month, so the recent increase in SHIELD Act enforcement is especially timely. Next slide, please. As background, the New York SHIELD Act became effective in October of 2019 and requires persons and organizations that own or license any New York resident electronic data to maintain reasonable data security safeguards. On the business side, this means that any company that has any New York resident data, whether the company is based in another state or in another country, needs to comply with the SHIELD Act. Next slide, please. Reasonable data security safeguards include administrative, technical, and physical safeguards. On the slide, you can see a few examples of what constitutes a reasonable safeguard. I'm discussing the recent uptick in SHIELD Act enforcement today, but if you have any other questions on any of these practices, please reach out to the cybersecurity and data privacy team here. Next slide, please. The SHIELD Act defines a security breach as any access to computerized data that compromises New York residents' private information. In the event of a data breach, the SHIELD Act requires that a business notify affected consumers as soon as possible. Not only have we seen several employers fail to implement the proper SHIELD Act safeguards, but we've also seen enforcement action commence when companies fail to properly handle the data breach. Next slide, please. Under the SHIELD Act, New York residents have no private action against companies failing to maintain data security safeguards or in the instance of a data breach. Instead, the New York Attorney General is authorized to enforce the SHIELD Act by enjoining violations and obtaining civil penalties. Recent activity indicates that New York has increased its focus on SHIELD Act compliance and will readily send warning letters or impose financial penalties. Next slide, please. Under the SHIELD Act, New York residents have, one recent Attorney General settlement was with IMED. IMED suffered a data breach when hackers accessed IMED email accounts containing sensitive emails. In addition to all of the compromised information, the investigation revealed that the hacker used compromised accounts to send phishing emails to clients. After the investigation, IMED was required to pay New York State $600,000 for SHIELD Act violation. IMED was also required to bolster their cybersecurity systems by monitoring network activity and encrypting sensitive information, for example. Next slide, please. Following IMED, the New York Attorney General settled with Wegmans, which is a national grocery store chain near and dear to our hearts here in upstate New York. The Attorney General advised Wegmans for violating the SHIELD Act in failing to protect customers' personal information. Wegmans agreed to pay the state $400,000 and adopt additional security measures under the settlement. Additional security measures included maintaining an information security program, establishing customer password policies, and updating data collection and retention practices. The New York Attorney General really emphasized that organizations should only collect customers' personal information for reasonable business purposes. So any company listening on today's call would benefit from keeping that in mind. Next slide, please. In a multi-state investigation, the New York Attorney General recovered $1.25 million from Carnival for a 2019 data breach. A hacker accessed employee email accounts, resulting in a breach of New Yorkers' personal information. In addition to the fine, Carnival agreed to strengthen its security and breach response by requiring email security training and undergoing independent security assessments, for example. Next slide, please. Finally, Zoetop was fined $1.9 million by New York State after it failed to inform customers of a data breach that affected millions. Zoetop is the parent company of Shein and Romwe, which are popular online fashion websites used often by high school and college-age shoppers. In 2018, Zoetop was the victim of a cyber attack. Zoetop's payment processor alerted Zoetop that Shein customers' card data was found in an online forum for sale. A private investigation concluded customers' names, email addresses, and hashed account passwords of certain customers had been compromised. Instead of notifying all affected customers, Zoetop contacted a subset of those impacted and misrepresented the data breach size and scope. 2 years after the initial cyber attack, Zoetop found customer login information for Romwe customers available on the dark web. Only then did Zoetop take action to protect many of the impacted customers and force password reset. Takeaways from the Zoetop case include proper password management, regular monitoring of security incidents, and having a written security response plan to take action. Next slide, please. The New York Attorney General's action serves as lessons to businesses collecting or maintaining data of New York residents. If you take away one thing today, it would be to implement SHIELD Act safeguards proactively. It's been said before, but the best offense is a good defense. By implementing safeguards in advance, organizations can prevent cybersecurity risks and related financial penalties. Feel free to reach out to me or any attorney in the cybersecurity or data privacy team to discuss prevention and planning. That's all from me, Adam.
Thank you, Maureen. It's quite interesting, the scope of the SHIELD Act and how many different businesses are impacted by it. you may think, well, we don't collect a ton of customer data, but you don't know for sure if you're going to be come after by the Attorney General in the event of a hack or information that's stolen from you electronically. So we have a cybersecurity team here. There is a group of attorneys that are dedicated to dealing with these types of issues. So if you have questions, please feel free, reach out to Maureen or anyone else in that group. Maureen, I believe that you also prepared a blog article for this, or an information memo. Is that right?
I did. There's a lot of additional information available on the website.
Okay, so please be sure to check out our website for written materials on that as well. All right, well, thank you all for being with us again on this Tuesday. As always, if there are topics that you want us to cover, things you find interesting, please let us know in the survey responses, and we will be happy to cover those topics for you. So great to see you all, and we'll see you again next Tuesday.